Hey, welcome back to this mini lecture on freedom of the press, additional legal cases. Schenck and the U.S. is an example of clear and present danger. During the First World War, Schenck mailed circulars to various draftees. These circulars suggested that the draft was wrong, motivated by capitalism. They specifically urged the readers to do not submit to intimidation and advised peaceful acts like petitioning to repeal the Conscription Act, which caused this draft. Schenck was charged with conspiracy to violate the Espionage Act. He was attempting to cause insubordination in the military and obstruct recruitment. That was what was alleged. And the major issue is, are Schenck's actions, his words and expression, protected by the First Amendment's free speech clause? At that time, it was a 9-0 decision in favor of the U.S. According to the Espionage Act and the First Amendment of the Constitution. It was found that Schenck was not protected in the situation. There's three reasons, a part of it. The character of each act depends on the circumstances. The question in every case, for the legal case, is whether the words used are used in such circumstances and are such a nature as to create a clear and present danger that will bring about the substantive evils that Congress has a right to prevent. And as a result, during wartime, utterances tolerable in police time can be punished. So what Schenck did was seen as a clear and present danger. Texas and Johnson, it was dealing with the flag. Gregory Lee Johnson burned the U.S. flag to protest against Reagan administration policies in front of the Dallas City Hall in 1984. He was convicted under a Texas law outlawing flag desecration. He was sentenced to 1 year in jail and given a $2,000 fine. After the Texas Court of Criminal Appeals reversed the conviction, the case went to the Supreme Court. And the issue is desecrating an American flag, such as burning it, a form of speech that is protected under the First Amendment. Here it was decided in favor of Johnson, according to the First Amendment. The Supreme Court in its holding found that Johnson's burning the flag was a protected expression under the First Amendment. And then in terms of the reasoning, Johnson's actions fell into the category of expressive conduct and had distinctively political nature. An audience taking offense to certain ideas or expression does not justify prohibitions of speech, at least in this case of Texas and Johnson. Also, officials did not have the authority to designate symbols to be used to communicate only a limited sense of messages like the flag. And here's a quote from the reasoning. From the ruling, if there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. Finally, for this purposes, this deals with Chaplinsky in New Hampshire about fighting words. Chaplinsky publicly called the city marshal a goddamn racketeer and a damn fascist. He was arrested and convicted under state law for violating a breach of the peace. The underlying issue is, does the application of the statute violate Chaplinsky's freedom of speech that is protected by the First Amendment? Here, the speech was not protected. Some forms of expression, like obscenity and fighting words, do not convey ideas and thus are not subject to First Amendment protections. Chaplinsky uttered fighting words, and these are defined as words that inflict injury or tend to incite an immediate breach of the peace. So fighting words can be found to not be protected by the First Amendment. That was freedom of the press, additional legal cases. As always, thanks for watching. Take care. I hope to see you again soon.